to the international webinar on protection of right to life and right to livelihood during COVID-19 pandemic. For today's session, we have with us former chairman of National Green Tribunal, New Delhi, and former Justice of Supreme Court of India, Honorable Mr. Justice Swatantra Kumar, and along with him, we have Honorable Mr. Justice Michael D. Wilson, Supreme Court of Hawaii, USA. Moving towards today's session, it is requested to all the participants to fill the feedback form, which shall be circulated both on Zoom chat box as well as YouTube comment section during the session to mark your presence. Now, I would like to call upon Professor Dr. Yugal Kishore, Dean, ICFAI Law School, to give welcome address. Over to you, sir.
Thank you very much, Madam Anushbi Jain.
Thank you, sir.
Good morning and aloha to one and all present here. Respected keynote speakers of the day, Honorable Mr. Justice Swatantra Kumar sir, Honorable Mr. Justice Michael D. Wilson sir, and distinguished faculty, academicians, Registrar of the University, Brigadier Sethi sahab, law professionals, organizers of the international webinar, Madam Monica Kharola, Madam Ekta Gahlawat, Madam Anushbi Jain, Mr. Vishal Mehra, and dear student friends pan India. At the outset, I take this opportunity as the Dean of ICFAI Law School, ICFAI University, Dehradun, to wholeheartedly welcome one and all, and especially the two keynote speakers of the day, Honorable Mr. Justice Swatantra Kumar Sahab and Mr. Justice Michael D. Wilson Sahab. In fact, I would like to speak a few words about this university and the school. So, ICFAI University, a constituent of the ICFAI group, Hyderabad, was established by a great educationist and institution builder, Mr. N.J. Yashashiv, in the year 2003 by an act of legislature of Uttarakhand. From that time itself, it has been maintaining high standards of education and research in the country. And for that, it has been ranked 44 as in the category of World University with Real Impact by United Nations Institute of Training and Research. It has been also recognized as e-lead university for its capability of providing online education for this year. So, ICFAI Law School, right from the beginning, has been imparting standard legal education with professional skills of advocacy and research proficiency. And therefore, this year, in the year 2020, it has been ranked among top 20 universities of super excellence by the CSR and CHRDC in the country and first in the Uttarakhand. It has also been ranked 26th among the top universities, including national law universities, by MRDA Survey of India Today 2020. So now a few words about the topic. Of course, we have a very, very learned, eloquent jurist today to speak about it, but then Article 21 of the Indian Constitution on the chapter on fundamental rights provides that no person shall be deprived of his life and personal liberty except the procedure established by law. Here, right to life does not mean only the extinguishment of life. It includes that the life should be with full human dignity and potential to develop the personality of the person. And therefore, because of that, the right to livelihood has become a very important aspect of the right to life. Because until and unless right to livelihood is protected, life with dignity will not be also provided, and right to life is hampered. And particularly during this COVID-19 pandemic, we have seen that a number of lockdowns were there. Even if the things are opening briefly, shortly, but then still a large number of persons, they have been without their profession, occupation, and livelihood. And particularly, in India, we have seen that a large number of laborers and other skilled persons have migrated from their place of job to their villages in order to protect their life. In this situation, they have lost their livelihood. Of course, Indian government is providing a number of schemes for self-employment, calling it by the term Atmanirbhar Bharat. But then at present we are finding that many persons are not having their proper livelihood, and therefore their life is not protected under Article 21 of the Indian Constitution. And therefore we have and we know that there should be some line of demarcation between right to livelihood and right to life. For that, we have a very eloquent, learned, lucid, and jurist personalities with us. One, Honorable Mr. Justice Swatantra Kumar ji, who has been the former Justice of the Supreme Court of India and the Chairman of National Green Tribunal. We have gone through with a number of his cases in which he has provided justice to the persons. And then we have with us Mr. Justice Michael H. Wilson Sahab. He is from the Supreme Court of Hawaii, United States of America. So now, before our lauded speakers start, I request the Miss Ekta Gehlawat to please provide a brief introduction about lauded speaker of the day to enlighten us. Thank you.
Thank you so much, sir. Now I would like to start with the introduction of Justice Swatantra Kumar. Justice Swatantra Kumar was appointed as the additional judge of Delhi High Court. Then he was transferred to the Punjab and Haryana High Court, from where in 2004 he was transferred to Delhi High Court. He was appointed as a Chief Justice of Bombay High Court in 2007. He had the occasion to deal with a variety of administrative and judicial matters. One of his contributions to establish courts at talukas at village level. Having served as a Chief Justice for nearly a period of 3 years, he was elevated as a Judge of Supreme Court of India on 18 December 2009. Upon being appointed as a chairperson of National Green Tribunal, he resigned as a Judge of Supreme Court of India on 2012. During his tenure, he was instrumental in delivering several landmark judgments, widening the horizons of environmental jurisprudence in India. These judgments have related to cleaning of river Ganga and Yamuna, air pollution, Himalayan glacier, municipal solid waste, and protection of forest. He introduced for the first time the practice of consultative process of stakeholders in dispensation of environmental justice. Under his leadership, the National Green Tribunal has held various international as well as regional conferences on environment in various parts of country, where many countries from all across the globe have actively participated and contributed to the burning issues of ecological conservation and climate change. For his contribution as a judge of Supreme Court of India, Chief Justice of High Court, and the chairperson of National Green Tribunal, he has been bestowed with 12 different awards, including the National Law Day Award, Life Achievement Award, International Human Rights Award, Bharat Jyoti Award, Distinguished Service Award by Indian Medical Association, and awards by other national and international organizations. He has also been nominated as a member of governing body of Global Judicial Institute for the Environment, which works under the United Nations Environmental Program, and has addressed various national and international conferences organized by the UN and the various other national and international organizations. Thank you so much, sir. It's our honor to have you with us today. Your presence cannot be merely marked with words. Over to you, sir.
Thank you, everybody. The management of ICFAI University, and particularly the law school, Dean of the law school, Mr. Kishore, Madam Ekta, other faculty members, and importantly, and specifically the attendees of this international webinar. I must compliment the university for having chosen a topic which has a great significance, not only at our country or domestic level, but globally. To say that right to life and right to livelihood during this COVID-19 period is a topic of very serious concern. And if one has to really talk about all the facets of this topic, probably it will be not possible, frankly, to cover that field in this short time. But I shall endure my best to cover the field and introduce you to the various facets of this basic human right, environmental and legal issues prevailing in the country and which the globe family is facing across the world. First question that arises is there a right to life and livelihood? Obviously, the chapter on fundamental rights in the Indian Constitution does not state right to life and right to livelihood as a fundamental right. But let's look up at the preamble of our Constitution. The preamble of our Constitution says that we are a sovereign, secular, socialistic state, republic, and which is to provide to its citizens social, economic, and political justice. Now, how do you provide social and political justice or economic justice to the people of India at large, unless and until you are certain that you will be able to give air, water, food to your people. Because if they have these three things, then they have some protection to the right of livelihood and therefore right to life. Because if you cannot have a right to live, then you can't have or a livelihood. You obviously can't have a right to life. So right to life in its true meaning is in absolute term dependent upon the right to livelihood. Now this expansion of fundamental rights was a result of judicial pronouncements by the Supreme Court of India in the last 2 decades. I have no hesitation in stating that the Indian judiciary, and particularly the Supreme Court of India, has been very progressive in expansion of law, and which I would put it in very simple words is the judicial creativity for human good. Now, when we talk of judicial creativity for human good and for the country, then we straight away go to Article 21. Article 21 is a one-line article which, by judicial creativity and expansion, has become an article most significant in our constitution today. If you recollect, it started with the case of Kharak Singh versus State of UP, then Menka Gandhi, then Sunil Batra, where the Supreme Court for the first time attempted to expand, keeping in view the preamble of the Constitution of India into mind, and said that right to life would include right to livelihood. It said right to life means to live with dignity, not animal existence. Then finally, even expanded it to say that you have a right to protect your heritage and protect your culture. This is how, over the time, Article 21 was expanded. And if we sort of correctly know that right to livelihood was specifically included by the Supreme Court in the Olga Taylor versus Bombay Municipal Corporation case, where the Supreme Court linked the right to life and right to livelihood as a absolute fundamental right. And not only that, the Supreme Court observed that it is the obligation of the state to ensure air, water, and food to its people and make their living decent and worth living. It can't be an animal existence. So that was the development of law. Then, as you know, that Article 21 has been expanded even to include right to education, right to decent and clean environment was created as a fundamental right in terms of Article 21. Having said this about the case laws and the other things that have been happening, now let's see what is the source of this particular right of decent right to environment and right to life and right to livelihood. Because let's face the facts. If you have a polluted environment, then other two rights lose their essence. Clean environment is a condition precedent for effective enjoyment of right to life and right to livelihood. Now, if we look at it, just making a reference to the international platforms, Let's go back to the UN Declaration of Human Rights in 10th of December 1949. Then you may talk of 1969 Vienna Convention, Stockholm, Montreal, Rio, and Paris. All of them are intended only to bring out one basic factor, that your living should and must have a direct link to a clean and better environment, so that you do not frustrate the substantive right by ignoring the basic right. That was the whole analysis. And as you know, that Article 253 of our Constitution empowers the Parliament of India to enact laws in furtherance to its international commitments. That is how all our environmental jurisprudence is referable to all these international convention agreements or now we straight away come to the sources which I just mentioned. We have constitutional law, that is the source is constitution. Second, statutory rights. And third is the rights emerging from judicial pronouncements, which we just mentioned. All these three sources bring right to life and livelihood to its truthful and proper meaning. The question that now arises, in fact, is that how do we connect this right? So now we have a constitutional right in relation thereto. So the question that arises now is that how do we link it to livelihood? Now, as you know, COVID-19 is one of the probably a disaster besides being a pandemic which has hit the globe. Now, it has been talked about, whether we talk of Harvard University, whether we talk of Stanford, or we talk of research institutions in US, UK, anywhere. Two facts are undisputed: that there is a definite human contribution by degrading your environment for widespreading of COVID-19. Now, if that be so, we need to first check, and how do we make the right to life meaningful by not if we don't protect our environment and natural resources. Right to livelihood is that under the directive principles under our constitution, the state is under obligation to provide air, water, food, but that directive principles per se are not enforceable under our constitution. But the fact of the matter is that the state policy is framed with the aim of achieving directive principles, because that is the umbrella for the government to frame its policies. As a result of COVID-19, there were restrictions put. Now it will straight away come a kind of an indirect conflict between Article 19 on the one hand and Article 21 on the other. Now Article 19(1) and its various significance, including freedom of speech, freedom of movement, freedom of culture and other things, all of them are subject to reasonable restrictions. The article itself talks that Article 19 is subject to reasonable restrictions under the Constitution. But Article 21 is not subject to any restrictions. It is an absolute right vested in the citizen, hence is a much above than Article 19 in terms of constitutional preference and constitutional priority. Once it is a higher right, all rights must be read in line with, and the right lessers or restricted rights must give way to Article 21 for being very broad and ensuring its implementation. Now, when we talk of implementation, is Now let's just get on to the realities of life. Because of the restrictions imposed under COVID-19, there are two main legislations which are operated by the authorities for the purposes of controlling and checking. Now, one is obviously the Disaster Management Act, Disaster Management Act, and other is Interstate Migrant Workmen Regulation of Employment and Condition of Service Act 1979. Now, both these vest powers in the state to put restrictions in the case of epidemic or the pandemic to control in the general interest. So the test is reasonable restrictions. So whatever restriction the state puts on your rights must be reasonable. Reasonable must meet power of to enact, power to issue. Authority must be there. It should be in the general public interest, and it should have a rational nexus to the object sought to be achieved by imposing such a restriction. So by and large, the restriction imposed by the government were found to be within the order, and the Supreme Court did say in the current judgments, which I'll just mention before I close, is with regard to that those restrictions were held to be good, but their consequences on ground reality was found to be different. Now in Karnataka, the migrant labor got stuck. Now when the migrant labor, the rails were opened specially for them, then the chaos came that if the whole migrant labor leaves the Karnataka state, who will carry on the work when it starts? Then the government or state government tried to put restrictions of not permitting the people to leave the state immediately. So it was either way a catch-22 position. Now people were not permitted to go through transport means, but at the same time they had to walk. And they were in the borders of different states, they were found to be in problems. There were a lot of voluntary organizations, even the state governments, local governments try to help them. But the quantum or the influx of population was completely high then to the management that was possible at such a short notice. Therefore, there was a little conflict between the rights given and the restrictions imposed. If we talk this, you can further expand it to that the judicial role in this, as you know, that Supreme Court also interfered in this in the people and migrant misery of migrants suo moto action, and where it has issued in the 9th of May 2020 certain directions in regard to movement, in regard to providing aid, and it directed the central government and state government to identify standard migrants and need to provide them 24 hours service, establish desks, even food, etc. were directed to be taken care of. So that was a positive role played by the Supreme Court of India in given situation, with the reasonable possibility that the administration could carry on. Now, the cumulative effect of COVID-19 is with regard to that, yes, it does not take your right to livelihood, and therefore your movement could be restricted. As I told you, that there is a comparative hardness or the comparative hardship, the test applied by the courts normally for finding out whether the restriction is reasonable or does it completely vitiates and affects the fundamental right to an extent that it will become miserable for people to live. So we have to be careful on that behalf. Now coming just to the final part of my discussion with you this morning is that in COVID-19, we have learned very hard way, but certain good things have happened which would improve the right to livelihood as well as the right to life. For example, the hygiene levels have improved. Dealing with the municipal solid waste methodologies have improved. We have become environmentally conscious. we have become very health conscious people. We are trying to do what best can be done. For example, your current webinar itself is an indication that we can work without rushing to one place where some large number of people would get together and spread infection if it is not properly taken care of. So we learn certain good things which we can make part of our coming life and keep the society and the country at a safer place. I am just reminded of the two things, which is one is, of course, what the professor said, that, COVID-19 is a signal from God to the people on this globe, saying that all of you are here guests. Don't think and believe you are owners of the earth. So if you are a guest, you might as well live like a guest and maintain things, environment, natural resources, health of people. And second is, which you really need to answer the young generation particularly, is whether you want 5-star hospitals to treat you, or you would like to, your country, your administration, your state governments, and you would like to contribute and take health care so that you don't fall sick and don't have to go to 5-star hospitals and spend money. Wishing all of you the best of luck, best of time, and best of health. Thank you.
Thank you, sir, for making us fortuitous enough to witness a webinar having you a fundamental part of it. We would be grateful and much blissful to listen to your words, believing in exigency. Now, I would further proceed by introducing our next guest of honor, Justice Michael D. Wilson. Justice Wilson was appointed to the Hawaii Supreme Court on April 17, 2014, after serving as a circuit court judge of the First Circuit since May 10, 2000. As a circuit court judge, he presided over adult drug court, adult mental health court, and felony criminal trial court. Justice Wilson is a founding member of Global Judicial Institute on Environment and an adjunct faculty member of Jindal Global University in Sonipat, India. Prior to his appointment as a circuit court judge, Justice Wilson was the director of the Department of Land and Natural Resources, chair of the Board of Land and Natural Resources, chair of State Water Commission, and a trustee of Keholawe Island Reserve Commission. He was awarded a lifetime membership in the Western Association of Fish and Wildlife Agencies in 1999. Previously, he was a partner in a law firm of Pavey Wilson and Glickston and Hart, Wolf and Wilson, where he practiced civil and criminal trial and appellate law. Justice Wilson received his law degree from Antioch School of Law in Washington, D.C. and bachelor's degree from University of Wisconsin Madison. Thank you so much, sir. It's a privilege to have this opportunity of learning nuances of legal acumen and enlightened by your noble thoughts on the topic. Over to you, sir.
Thank you kindly, Professor Galawat, and I would like to say aloha and namaste. In Hawaii, we say aloha, which is, I think, very much the same meaning as namaste, recognizing the spirit in everybody. But I especially am grateful to be speaking to India and this very important audience. Thank you, Dean Kishore, for your kind invitation. And Professor Jain, I'm honored to be part of this presentation with you. And of course, thank you so much for all your help, Professor Galawat. But I do feel today especially compelled to make remarks that I hope will make a difference to this audience, and also remarks that will be worthy of one of the great justices of the history of the Supreme Court of India, who has been a partner with our Supreme Court in Hawaii. And of course, that is Justice Kumar. And I bring you greetings from our court, Justice Kumar, and thank you very much for the invitation as well.
Thanks, Michael.
Today, I'll be giving a presentation that includes some PowerPoint topics. I wanted to start off emphasizing in the context of this issue that perhaps this is a way, this webinar is a way of focusing those in the audience that mean to participate in the law and focusing on this idea of the future of humanity. Because of course, that is what's at issue now. We are facing an emergency of global proportions. Next slide. The concepts that apply to, yes, you can go on to the next slide. The concepts that apply to this idea of addressing an issue that threatens all of humanity calls upon the concept of the rule of law. And I think a theme for all those that go to law school, as well as those that become practitioners of the law, is a theme that there probably is no more powerful tool to advance humanity than the rule of law that applies the principle that we should make decisions on a just basis, equally, without giving favor to power, wealth, position in society, but make decisions based on the law and the facts as they apply. Next slide. So I'm from Hawaii, which, as you know, is part of the United States. Hawaii is a small island. It has 1.4 million people. Our state does. You have about 1.4 million lawyers in India. One of the reasons that I am hopeful about today's presentation is I hope 1, 2, maybe 3 people in the audience will realize that it's time for the rule of law to be exercised in a way that hopefully will be new, innovative, and brave, because this is what humanity's facing with a number of emergency issues that are before us. Next slide. We have in Hawaii what might be considered the ideal environment. If you look at these next few slides, you'll get a feeling of it. And in that sense, we have a treasure that's a treasure for all of humanity. And when you consider our hope for the future, it has to depend on a rather broad concept of the rule of law, and one that is applied by great judicial systems. And India is certainly one of those. And can we move on with the slides? It looks like we're sort of focused on one slide from my position. Yes, and we can keep going. Next slide. And as you go through these slides, you get a sense of what our future is like, because we're facing a pandemic that is a extraordinary threat, not just to our country, but to our state. And perhaps we should dispense with the slides because it looks like we're having trouble moving them forward. Yes, keep going. Because there is yes, we can stop at this slide. When I talk about the way that Hawaii depends on the rule of law, and the reason why I'm honored to be part of this presentation, the rule of law, many legal historians will say, originated in India, I'm sure you're all familiar with Ashoka, who introduced this concept of the rule of law after so much war that caused him to reflect on the meaning of life and justice. And he characterized justice in the codes that he put together that addressed freedom, such as religion, and even rights for animals, rights for, when I say religion, freedom of religion. Next slide. So this next slide is an example of what's being discussed today. We're not here for theoretical reasons. We're here to talk about an emergency and the role of a court. This is an organization of justices between the Supreme Court of India and the Supreme Court of Hawaii. You see Justice Kumar helped organize this, and we received help in a very important area, which I will also allude to, which is going to be more of an emergency in Hawaii and in India than perhaps most places on earth, and that's the emergency of climate change, which we have received great leadership on from your former Chief Justice Takar, Justice Sagri, and Justice Chandrachud as well, your soon-to-be Chief Justice. Next slide. You know, the coronavirus pandemic has been the subject of our Supreme Court's work for the last 5 months straight. The emergency that we're dealing with is the emergency that's being experienced by citizens whose freedom has been taken away by the government, and those are incarcerated citizens. And there are certain principles that apply constitutionally that deal with the issue of cruel and unusual punishment. This in a way calls upon the issue of how do judges make moral decisions required under constitutions. And in our Constitution, it says that we shall not have cruel and unusual punishment. It means that incarcerated citizens have a right to adequate medical care. Adequate medical care when you have an overcrowded facility and people who are exposed as inmates to the coronavirus brings up the issue of not only is it cruel and unusual, but what should the remedies be? Next slide. Remedies. Remedies in emergencies. Remedies that are applied through the rule of law. This slide is a busy slide, and I should mention that my PowerPoint's available to anybody in the audience that would like it, so you can follow up. And I'm sorry to make this such a busy slide, but you can see it starts with emergency. This is another emergency, like the coronavirus pandemic that occurred in the United States in World War II. And it caused our Supreme Court to make a decision that is now recognized as a big mistake. Our Supreme Court made a big mistake. During World War II, it made the decision to incarcerate people because they were Japanese. So the men that were on the Supreme Court that were applying the rule of law made an assumption that all persons of Japanese ancestry, because of their ancestry, would have a dangerous tendency to commit sabotage and espionage. There was a very famous dissent by a justice whose name is Murphy, and he said that there's no reason, logic, or experience that could be marshaled in support of such an assumption. What assumptions do we make in an emergency applying the rule of law? Well, as you'll see in the next slide, we can't make assumptions arbitrarily. They have to be based on propositions that in the United States stem from the concept of human dignity. And we can go to the next slide that refers to the fact that punishment cannot be grossly out of proportion to the severity of a crime. If you are an individual citizen whose freedom has been taken away, should you be released if you have the virus? Are you being punished because you have the virus? It's a principle in our country that even 1 day in prison would be a cruel and unusual punishment for the crime of having just a common cold. So in deciding the limits of the intervention of the rule of law to deal with an emergency and suspend the rights of individuals, these principles are of the utmost importance. And the next slide will refer to a principle that I guess has evolved since the time of Ashoka. In our state in particular, and to some extent at the United States Supreme Court, the Constitution of India has great significance. It's a much younger constitution, but it has great significance because the birth of this constitution came from a commitment to civil justice, a principle of nonviolence, and an extraordinary application of this principle through the rule of law, initially through Mahatma Gandhi and then eventually through the founding fathers of your Constitution, who have made it clear that the right to life is of supreme importance. Your Article 21, reciting the right of life, is called the Magna Carta, or the very essence of liberty. But in applying this principle to the emergencies that are emerging is a difficult proposition. Next slide. This idea of applying justice in an emergency, in the pandemic, has created great division in our court and resulted in a number of dissents around the reality and the truth of what the court is supposed to do. Because it is clear that even if it does interfere with the administration of a correctional facility, a prison, the court has a duty to intervene and to take action that may not be popular action with the community, but is required under the principles of our Constitution. Next slide, and this is the concept of judicial intervention. We have an emergency that was alluded to by Justice Kumar. That is your emergency, maybe more than ours. Next slide. This is an emergency that was discussed by this person may be the leading expert on climate change in the world, Sir David King. He gave a speech in China in which he referred to India and Bangladesh. He talked about a threat that's greater than the COVID pandemic, and that is the threat of climate change. You, India, and Hawaii have a bond. It is a difficult bond. It is a struggle we will face. In 40 or 50 years, 160 million climate refugees will be leaving Bangladesh, and most of them will head for India. In 40 or 50 years, we're going to lose most of our magnificent beaches. Our number one city will be flooded, Waikiki. When the rule of law is applied, and the justices of India make a decision about how this should be dealt with, if we don't take action to prevent global warming within the next 8 or 9 years, it will have reverberations throughout the world. Next slide. So the difference between the coronavirus emergency, the difference between the emergency of World War II that caused our Supreme Court to make a mistake and commit an injustice against Japanese people. Those emergencies pale in comparison to the climate emergency. As Sir David King has said, the difference between the coronavirus emergency and the threat from global warming is that humanity can recover from the coronavirus. Next slide. So this leaves the judges in the world in this very unusual situation. This is a cartoon, as you can see, of two dinosaurs we might consider to be judges of the world. They're conferring about the climate future, conferring about the principle that Justice Kumar alluded to or referred to, that we should treat the earth as our guest. So when the judges see, as we are required to when these climate lawsuits are brought to our courts, when the judges see what's coming, it's like the dinosaurs looking at the meteor. And do we just assume it's not going to be so bad? Or do we take action? Do we intervene? Next slide. So this emergency is interesting to contemplate from the point of view of the courts of India and the courts of Bangladesh, because you're facing the final stand. The idea that the rule of law may be available for solving these problems could be limited to just these 40, 50 years before there is a dramatic change in the plight of humanity such that the rule of law won't make decisions for countries. It will be a rule based on power. Next slide. So this emergency, how should we apply the emergency? Suo jurisdiction's a very interesting concept, not available in our country, but suo jurisdiction allows the court to act on its own, as Justice Kumar has famously done in a number of environmental cases, where the court initiated the case to protect the right to life by protecting the environment. There are principles that those of you in the audience, maybe it's more than 3, maybe it's more than 4, but it won't take very many. If you bring the right case and you use the rule of law and you have justices like justices on your Supreme Court, maybe we'll be able to deal with this emergency that transcends the pandemic emergency. Urgenda is a remarkable case. This is a case where the judges at The Hague, judges making a decision in the Netherlands, decided that there is a duty to protect citizens by reducing the amount of greenhouse emissions. And this is a result of a lawsuit being brought on behalf of future generations and children by creative lawyers. And it didn't take very many, as many lawyers as it takes to bring a lawsuit, brought this lawsuit. And it's had reverberations since 2015. And it has extended to the United States. And it has created a new form of litigation. Unfortunately, it's a new concept in the United States our courts are grappling with. But for the courts to grapple with it successfully, we need to have the participation of our civil society. Next slide. A civil society that includes, Lorenzo's question is just a question that this is a way in Hawaii of us talking about what can law students do? What can young people do? Next slide. And you've already started your leadership in India. Many of you in your audience may already be aware of this movement in India by law students and young lawyers who are not going to accept that judges will, like the dinosaurs in the cartoon, just watch it happen. Lawyers in India that bring the case to court and ask for the court to take a final stand. That's the final stand that's referred to with respect to the rule of law only being available for perhaps another 30 or 40 years, after which global warming will be a threat to the rule of law as well as to our international economic system. I have put the address, the web address for the final stand in this slide. Perhaps you can look it up, but it's If you go to Google, it's the very first entry that comes up with Final Stand India. Next slide. So these are the human beings in India who are standing up for the environment, making a final stand, and bringing emergency lawsuits, and are committed to protecting India from the effects of global warming. Next slide. You might say that India is further along than the United States on this issue. Our students have had to protest. Our law students have gone to the Supreme Court because so far our federal courts are taking an opposite position where they don't recognize this right of future generations, a right that would not be considered to be abnormal, would not be considered to be in any way extreme in India, the right of future generations to go to court and protect themselves from this emergency. I have two more slides. The next slide is one that just gives me peace, and it gives me a sense of hope. This is one of your great justices, Justice Chandrachud, who has made decisions about the advancement of human rights that are a prelude perhaps to the rule of law being used in India in a way that will be powerful, and maybe the decisions that are made by the Supreme Court with him as a member will be decisions that come as a result of somebody in this audience who, representing future generations of all humanity, will have the Supreme Court of India make a stand, be part of the final stand that allows us to succeed. And the next slide. You may ask why I am showing this tiger from India. Well, this is a very special tiger to me because it represents India. You're a very old country, but you revere nature. Ma Druga, who behind me, who was brought to me by Justice Kumar, the philosophy and faith of India, I think, believes that we can protect nature. And if we can still have wild tigers, and I was very fortunate to find this wild tiger with the help of some of the law professors of India, it means that we are being successful in our final stand, because it has to be an earth that we treat as a guest if it's an earth that we're going to share with tigers. And my final slide is to just say aloha, and once again, namaste, and tell you how grateful I am that I had the opportunity to speak to this extraordinary audience in India. And I thank all of you for the opportunity to do that. Now it is 8:30 in Hawaii, and I guess it's morning where you are, but I am very hopeful that someday I'll be in your time frame again when I can return to India once again to learn from you and see how the final stand is progressing. And thank you very much.
Thank you so much, sir, for a very informative session, sir, and briefing us about the current environmental situation in India. It was a very interesting learning moment for all the participants all across the world, sir. Now, with due permission, sir, should we begin with the question answer session, as I being the moderator of the session?
Go ahead.
Thank you so much, sir, for your permission. The first question to Lordship Wilson is that, sir, the question to you: is the culture of dissent required for dignity full of life under Article 21?
I think the question was, is the culture of dissent, did you say?
Yes, sir. The culture of dissent required for a dignity full of life under Article 21.
This is one of the most wonderful questions I have ever been asked. And I guess it reflects the bravery of India. Absolutely. The culture of dissent is critical because it moves forward the rule of law and it allows for its evolution. And where judges are willing to recognize that the application of the rule of law to protect the dignity of human beings and protect the right to life means a decision that may not be popular. It's a sign that the courts are moving forward on behalf of an entire nation, and perhaps not just a community of nations, but a community internationally. So I very much respect the culture of dissent, and look oftentimes when I'm reading decisions for the dissent first, because it gives me more information.
Thank you so much, sir. The same question in a different manner has been raised before Justice Swatantra Kumar, sir, is that what is the status of culture of dissent in India during the pandemic COVID-19 situation?
See, right to dissent is a recognized right in law. You do not have to think before you dissent. The question is, what do you dissent from? As I told you, that there can be, if you dissent, whether a restriction should be imposed or not, you should have the courage to dissent, but at the same time accept it if it meets the tests provided under the law. So right to dissent is not an issue, I think, as Michael just said, and it's very true that all over, for a proper appreciation of law, and in fact for development of jurisprudence in law, it is important that the dissent is discussed. So dissent, I don't think, should be an issue, but the test of dissent should be universally accepted.
Right, sir. Thank you so much, sir. The next question again goes out to you, sir, is that how COVID-19 is questioning the constitutional fabric in India.
See, COVID-19 is a pandemic, so it can't question the constitutional elements of the country. That's absolutely not in the right direction. But yes, as I told you, that the COVID-19 being a pandemic of a very serious consequence, and which has practically stopped our economic, social, and political growth temporarily during this period, that is subject to restrictions, and the restrictions have been imposed by Delhi government, central government, state governments in the larger public interest. So COVID-19 has not touched the constitutional fabric, because COVID-19 is a disease, it's a pandemic, but its impacts have definitely caused certain very serious environmental questions and the constitutional questions to be discussed. Now you will have to decide whether your environmental rights must give in all the time for the purposes of unsustainable development, or should they be in a sustainable way to ensure that the people do not get. That's why I told you whether you want hospitals or you want healthcare. So you have to decide it first. It is that kind of a situation which matters, and I don't think our constitution is very strong. It's a very widely spread, it's a vibrant document. It has always accepted the need of the society. Yes.
Thank you so much, sir. The next question goes out to Justice Wilson, sir, is that what is the status of human rights worldwide in the age of this pandemic?
Well, this is a grand question. Covers a lot of territory, and the state of human rights in the world is definitely being challenged. And this is a time for lawyers who care about justice to be especially vigilant. For example, one of the areas in which we have disagreement among our court is what freedoms should be put on hold, what freedoms should be suspended. And our court has gone so far as to suspend freedoms that pertain to citizens who are being arrested and taken into custody on the basis of the potential danger of bringing inmates into court because they our prison now has the virus on the basis of potentially causing danger to court staff, causing the virus to spread outside the community, citizens who have not even been tried yet, who are only accused of a crime, that are arrested and taken to jail or having their rights suspended, to come to court and get a trial date, to come to court and be informed of the charge against them. This is a profound change in a democracy like India or the United States or so many democracies around the world. And our court has disagreements about whether the nature of the emergency is such that we can do that instead of taking measures as a court to bring in our citizens in a way that doesn't cause the spread of the virus. So I'll conclude by saying, if you look around the world at healthy democracies, no doubt there is a concern that too much freedom may be taken by the government. And in those communities that unfortunately do not have a strong rule of law, it's an opportunity for abuse by the executive branch and an opportunity to compromise citizens' rights in a way that may mean that it's very difficult for them to get back. So my conclusion is, now more than ever, it's important for attorneys to go to court and be vigilant to enforce the rights of citizens of all races and citizens, whether they're in custody or not.
Thank you so much, sir, for the answer. And the last question of the day goes out to Justice Swatantra Kumar, sir. That is, sir, the question was asked by Professor Singh is that, is the judiciary obliged to test whether citizens had been deprived of their livelihood in a just and fair manner?
Yes, it will be open to if the state takes a call and imposes a restriction which affects the livelihood of people. The Supreme Court or the High Courts, in exercise of its extraordinary jurisdiction under Article 32 or 22-26, can certainly examine whether such a restriction which has been imposed affecting the livelihood can be at all sustained. And if it can be sustained, whether it satisfies the triple test of having legislative competence, reasonableness, rational nexus, and public interest. And in any case, since it will directly be affecting the right to life, so courts maybe have to be doubly cautious while testing this.
Thank you so much, sir, for answering the questions of the participants. Now I would request our academic coordinator, ma'am, Monica Carola, ma'am, to kindly take the mic and read the vote of thanks to the speakers of the day.
Thank you, Vishal. It's with great pleasure and honor for me to give a vote of thanks to our highly honored speakers for the day, Honorable Mr. Justice Swatantra Kumar and Honorable Mr. Justice Michael D. Wilson. Sir, I begin with Aloha and Namaste from India. It's been a pleasure to hear you and to hear Justice Swatantra Kumar on this topic, which is of immense importance to all people all over the world, not only in India, but all over the world. We've been privileged with your views and opinion because if there is livelihood, then only, as you rightly said, that right to life is possible. And as a democratic state, it's the duty of the courts, and the courts must be helped by the civil society and the lawyers. And definitely, as suggested, that the young budding lawyers who are in the law schools or passing out, they have an important role to play because the nature of the state is changing dramatically with the problems that the world is facing. This is only, as you said, a very minimal pandemic, which will get over and things will go. But environmental changes or other changes which will cause irreparable and non-reversible changes will be difficult to bear if they cause and they are at the cost of humanity. So all our human rights discourse must be towards working for protection, and like your ownerships, the courts, if they are there with the people, we hope that the interest of humanity will be protected. I, on behalf of ICFAI University, Dehradun, would like to thank both the judges in India and USA for having been so kind to take out time and talk to our students. Your presence, apart from the deliberation that you have so wonderfully given, also motivates, encourages, and gives them the hope. And among them, you rightly said, there will be few who will aspire to do good and be good. We thank you on behalf of the university for motivating, encouraging us to take up this challenge and making it a grand success. And to our students, I hope your message goes loud and clear. You are the tomorrow. Please help us to protect the world. Thank you, Your Honor. Thank you for being with us. With all due respect, I would like to hand over to our Dean, sir, for a last word of thank you.
Thank
Thank
you.
you very much, sir. Thank you, Monica Madam. Today's juristic discourse on the topic of protection of right to life and right to livelihood during pandemic 2019 has been very, very interesting, fruitful, lucid, and informative. So I am very much thankful to both of you for your judicial discourse on the matter, and we wish that in future also we will be associated and you can in the same way enlighten us and motivate us, sir. Thank you very much. Very kind of you.
Thank you.
Thank you. Michael,
Yes.
there is another people, they may be writing to you in a day or two, okay? They will
Yes.
be requesting you, but they'll take appropriate time from you, okay?
Will you be part of is this another webinar?
Yeah. I'll
Okay.
let you know on the day, okay?
And you will be
Thanks.
part of it also?
Yeah, thank you so much. And God bless you.
God bless you too, Brother
Thank
Kumar.
you. So we leave the meeting. Dean Saab, thank you. Ekta ji, thank you. And everybody else, thank you.
Thank
So
you
from
so
the core
much.
of heart, I also thank both of you, sir.
Namaste.
Sir, from the core of heart, I thank both of you. Thank you very much, sir. So with your permission, may I close the meeting?
Yes, thanks very
Thank you.
much
Thank
to
you, sir. Thank you, sir.
ICFAI. It was a wonderful opportunity, and I thank you for all your efforts. And it was also very impressive that you were so organized and were able to get the materials to me so quickly. I marvel sometimes at the administrative ability of institutions in India. So thank you.
Thank you very much, sir. Thank you very much. Thank you. Very kind.